G'day everyone and welcome to the first lecture for Laws 11061, Contracts A. My name's Anthony Marinac and I'm going to be the lecturer for this subject this term, and for those of you who can put up with me, I'll also be the lecturer for Contract B as we do the second half of the course next term. During this first lecture, we're going to keep things fairly simple. We'll talk about the general nature and purpose of contract law, and we'll talk about a few of the basic theories of contract law, the classical theory, promise theory and consent theory. We'll talk a little bit about the Australian consumer law and some of the equitable principles that flow from that, but really our focus today is going to be on getting to know one another, me telling you a little bit about the course and why we do it, and then we'll have a bit of a yarn about theory. So let's jump into it. Look, the first thing I'd have to put on the table and acknowledge up front is that most of you are probably not too excited to be studying contract law. There's lots of students who come along to law school and they've seen a lot of TV and they're very anxious to study criminal law, and they quite often want to know all about torts, or there are people who get fascinated by constitutional law, or they're interested in family law or environment law. There's not too many students who turn up and say, listen, where can I get my contract law at? I'm really excited to hook in and study contract law. And there's even less of that excitement when students find that in first year, usually in your first semester, for some of you this is your first week of university study, and you find, oh my God, I've got to study contract law. Why are they doing this to me? Pretty fair question, really. I'll try and give you some answers. The first thing to know is that contract law is everywhere. It is absolutely everywhere. You've all heard the saying that money makes the world go round. Well, that's actually nonsense. It's contracts that make the world go round, because without a system of contract law, the money would just be funny bits of paper and little bits of metal. It's contract law which underpins our system of commerce and allows you to trade that money securely for goods and services. So an understanding of contract law is really, really important for any lawyer to have. And in fact, you'll find that an understanding of contract law will help you in your daily life, even while you're still a student. The second thing is that contract law is something that you're going to have to understand in order to go on and successfully study some of the more advanced subjects, in particular property law, also corporations law, and to a lesser extent equity law. So when I think about what I'm trying to accomplish with you all during this term, it's partly about teaching you contract law, but partly what I'm really also about is setting you up to be successful students when you come to study property law, corporations law, equity and other subjects like that. So we need to see that contract law is a basic foundational subject, and you then get to build on that more as we come down the track in your degree. The third thing about contract law is its source. You can look as long as you like through the Queensland statutes or the Australian, the Commonwealth statutes, and you will not find a Contracts Act. You will not find any real legislation apart from possibly the Australian consumer law, which would tell you about how contract law works. Contract law is actually older than that. Contract law developed slowly over time through the gradual accumulation of judges' decisions. So what happened was that the idea of commerce predated even the idea of a system of written laws in the common law style. And what the courts did was they gradually recognised over time the customs of business which were already in place in society and in the economy. And then there was the two bouncing off one another. So the law began to affect the way that commerce worked, and commerce affected the way that law was interpreted. And gradually, through an accumulation of these judges' decisions, we end up with a thing that we call contract law. Now, what that means, of course, is that for us as a group to learn about contracts, for us to understand contracts, we're not going to be able to go to a piece of legislation, read it, learn about it, and then say, now we understand contract law. What we do have to do is go through a whole bunch of cases and work out from those cases what they call the ratio decidendi, or the point of law established by the case. And then we have to knit all of those together to come up with something that looks like a coherent body of legal principles. Now, this is really quite hard, but it's also a fundamental method of legal reasoning. And contract law is a great place to learn it. If you can't do it in contract law, you're not going to be able to do it for torts. You're not going to be able to do it for constitutional law. You're not going to be able to do it for any of those areas of law which rely heavily on judge-made law. So again, this plays into the idea that what we're really trying to do in this subject is not just teach you about contract law, but set you up with a set of skills to make you a successful law student down the track, and of course a successful lawyer once you've completed your study. So hopefully that gives you a bit of an idea and a little bit more of a justification as to why it really is useful and important for you to give this subject a great deal of attention as you head further on into your degree. Let's have a bit of a look at the outline of the term. I've really divided the term up into two phases with a very brief skills phase in the middle. In the first phase of the course, starting next week, we look at what are called the principles of contract formation. Now, these are principles that every lawyer is really expected to know virtually by heart. And in these topics, we ask ourselves, who can make a contract, and how do we tell if a valid contract has been made? What are the elements that we need to look at to see whether there is, in effect, an actual contract that the law is going to be prepared to enforce? This is a really fundamental area of law that you'll be expected to know forever. And so we're going to go into it in quite a bit of detail and teach you how to be really systematic in your analysis of contract formation. Once we've done that, we come to topic 7. We're going to look at skills for a week. Now, I've really rearranged this program from how it used to be in previous terms. Week 12 used to be what they referred to as a revision week, but that was always really a bit of a farce because the revision week just became a week off for everyone to start preparing for exams or go down the coast. It wasn't really that helpful. So what I decided to do when putting this subject together is take that week, that non-teaching week in year 12 and bring it in week 12 and bring it back to week 7. And we'll talk there about some fundamental skills. So we'll be talking about contract law, but we'll really be using contract law as the basis for discussing the skills that we're going to be talking about. And the skills we'll be looking at is how to tackle a problem question. Now, a problem question is something that really is unique to the study of law. Those of you who've done arts degrees or commerce degrees or whatever beforehand probably won't have come up against a problem question. A problem question puts you in the middle of a legal dispute. It says, here is the dispute, here is the side of the dispute that you're advising. All right, lawyer, go ahead and give them some advice. Do the legal analysis and tell them where they stand. Now that sounds easy, it sounds like a lot of fun. It is a lot of fun, but it can be complicated to do well. And one of the things that we've found CQU students later in their degree, and I teach third year evidence law, so I get to see this for myself. One of the things that we've found is that students really don't necessarily have these skills by the time they get to third year. Many students have been struggling along through their degree, trying to work out how to write a successful problem question, and they get better at legal analysis by third year, but they're really not at the point where they would probably want to be. They're really not at the point where they can fire off an excellent problem question, excellent answer to a problem question. So what I'd like to do is take some time out in the middle of the term, before your assignment is due, and certainly before we get to the examination at the end of the term, to say, right, here's how we tackle a problem question, and here's how we do it well. Then we come to the second phase, phase 3 of the term, which is the second phase of really substantive material about contracts. And that runs from topics 8 to 12. For these topics, we start with the assumption that we have a contract, because we've already done that in contract formation. Then we ask, how will the court read and interpret the contract? What do we need to know about the rules that the courts have for reading and understanding what a contract means? How do those rules differ if we're talking about a written contract or talking about an oral contract? And do those rules change if we're talking about express terms, which are actually written down on the face of the contract, and implied terms, which the court has to be prepared to read in from outside the contract? By the end of that third phase, you'll be in a position where you know how a contract is formed, you know how a contract is read, and then we can go on to contracts B next term and start looking at how a contract is discharged and what happens in the event of disputes or breaches of the contract. So that's the roadmap of where we're going, and hopefully that gives you a bit of an easier understanding of how all of this fits together. Let's have a look now at contract theory. Now look, a lot of you guys are going to be going to sleep the moment that you hear the word theory, because law students don't really deal with a lot of theory except in the subject that we call jurisprudence, which is basically legal theory. And you're probably wondering, why are we bothering to learn theory? And come on, Anthony, just teach us about contracts instead of talking about theory stuff. Well, the truth is that understanding the theory is going to help you understand the contracts, because it gives you a frame of reference. It starts giving you some analysis to make, some thoughts to have about the way that contracts work and the way that they're meant to work, without basing your thoughts on the vibe or some general basis of what you might consider to be justice. So let's start with classical contract theory. If we go back to the 17th, 18th, 19th century, we've got a time when the world was bursting with empire and there was all sorts of trade going on. Gold, silver, spices being brought back from the Indies and then from the New World after the Americas were discovered. The United States itself sought and found its independence and then burst into a culture which is really best known for its unrepressed mercantilism. As all of this activity happened, contract law started to develop. And it was developed on the idea that people were able to make private laws binding only on themselves. So the idea of a contract was that a contract really set up a law. But the law, which was set up in that contract, was only binding on the people who had signed up to the contract. So I've given an example in the notes. This is the example of Amber and Gary. Gary's going away and Amber wants to borrow his car. So they make a contract where Gary lets Amber have the car. She pays him a certain amount of money for fuel, and she agrees that she won't use the car if she's been drinking at all. Now what you can see here is that she's got two different legal obligations when it comes to alcohol. The law of Queensland says that she's not to drive the car if her alcohol is over 0.05. But the private law that she's made with Gary says that she's not to drive the car if her blood alcohol level is above 0.00. So if her blood alcohol level was 0.03, she would be perfectly within the law of Queensland, but she would be breaching the private law that she had made with Gary. It's quite a neat way to think about a contract, really. You think about any sort of contract. You go down the shops and you buy a can of Coke. Well, when you do that, you're forming a contract which is almost immediately discharged with the shop. And the contract says that you have a lawful obligation to pay them $1.50 and they have a lawful obligation to give you a can of Coke. And if you try and take away the can of Coke without paying $1.50, well, you've breached that contract and you can get in trouble. If they take your $1.50 and they don't give you the can of Coke, well, they've breached that private law and they can get into trouble. It does make sense as a way to look at contracts. Classical contract theory, however, ran into a few problems because what happened, particularly in the 19th century, but it started way, way earlier than that, was that the law really only was interested in enforcing the contract, and it wasn't really interested in the underlying justice of the contract. So you might have, for instance, if we think about the Industrial Revolution era, you might have people who have a contract of employment that requires them to work 16 hours a day, 6 days a week, for very little money, and the law didn't care. The law was only interested in saying, well, has this private law been made? And if it has, well, we're going to enforce it. That really led to the classical idea of contract theory being in a bit of disrepute. It's still, though, in my view anyway, a very useful way to understand or to have one perspective on what a contract does. If you're looking at any sort of contractual problem or any sort of contractual principle, you can always stop and ask yourself, okay, how does this work in terms of two parties or more parties making a private law binding only on themselves? So that's the idea of classical contract theory. The next one we'll move on to is promise theory. Now, for me personally, I think promise theory is probably the best of the theories that we'll look at today, and just instinctively, promise theory is the one that always pops into my head when I'm using theory as a basis for assessing contracts. Promise theory says people make promises. And some of those promises need to be able to be enforced. So contract law, according to promise theory, is a way of marking out which promises are going to be enforced by the courts. So in the coming weeks, when we look at contract formation, what we're really looking at is the question of which sort of promises which might be made by one person to another is the court going to enforce. Now, why is this important? Well, really, the world runs on promises. Most transactions that happen don't happen simultaneously. For instance, the plumber turns up to do some work in your bathroom, and you've agreed to pay the plumber an extraordinarily high amount of money per hour because that's pretty much what they ask for. People think lawyers are thieves. You've agreed to pay them lots and lots of money per hour. You don't sit there and every 5 minutes give them another bit of money and give them another bit of money. Essentially, they come in and they do the job and then they give you an invoice. And the reason that they can give you an invoice is because they know that you have promised to pay. Or if you paid them up front, you're paying them, but they haven't done any work yet. And the reason that you can comfortably pay them is that they have promised to do the work. If you get a credit card, the bank is giving you money and you are promising to make regular repayments. Pretty much any sort of contract can be reduced to the point where we say, who's promising what? And how do we enforce that promise? This is something that I promise, there you go, I wonder if that promise is enforceable. This is something that I promise is going to be useful to you throughout this semester and the next one. You can take any contract and think, all right, who is promising what and how do we know whether it's enforceable? How do we know whether they've delivered? And what should we do if they haven't delivered? That's the foundation of promise theory. To me, it's incredibly useful. There's a development of promise theory called consent theory. Now, consent theory is academically very sound, but for some reason or another, to me, it just doesn't resonate quite as well as promise theory does. I'll explain it to you, but I'm not certain that it really explains anything more than promise theory does, and I'm not certain that it's quite as useful in terms of providing a frame of reference as promise theory. But let's have a look anyway. Consent theory starts with the idea of rights. We have rights in relation to things, in relation to society, and in relation to one another. Now you can see that on the slide there. What does it actually mean? Well, we have rights in relation to things because if we own something, that gives us a bunch of rights in relation to it. We might have the right to possess it, to have it within our personal control, the right to use it, the right to paint it pink, the right to sell it to another person, the right to take photographs of it, the right to destroy it, the right to give it away. Okay, these are all rights of ownership. And we have rights in relation to those things. In relation to society, we have rights. We have our political rights, our legal rights. And in relation to one another, we have rights. I have a right to know that you're not going to hit me, no matter how bad of a lecturer you might think I am. You have the right to know that I'm not going to discriminate against you or harass you. So you see, there's a situation where we have rights in relation to one another. The thing is, though, all of these rights, whether we're talking about rights in relation to things, society, or one another, we can agree to forego. So, for instance, if I sell an item to someone else, what I'm really saying is I hereby forego all of the rights associated with my ownership of this thing because I'm giving it to you. You now own it and you take up all of those rights associated with ownership. In relation to society, we could do the same. There's no reason why we couldn't say, I give up my right to vote. In Australia, of course, we have a duty to vote. In the United States, it's quite different. People give up their right to vote or fail to exercise their right to vote any time. In relation to one another, we can give up rights. I might have a colleague turn around to me and ask for my opinion of her outfit. Now, normally in the workplace, I would never dream of commenting on the physical appearance of another workmate because that's really not something that's appropriate to do. So she has the right to wear whatever she thinks appropriate in the workplace without me commenting on her personal appearance. But she can forego that right by saying to me, Anthony, what do you think of this skirt? Okay, now by asking that question, she's foregone that right. The right to one's physical integrity, you could give up that right by agreeing to play a game of rugby league. Okay, if you agree to play a game of rugby league, you're basically saying, I give up the right to be able to walk around in the next half hour without anyone touching me. If I have the ball and someone wants to tackle me, I accept that that's a legitimate thing for them to do. So you can see we all have this underlying set of rights, but then we have the ability to give up some of those rights. Consent theory in contract law says a contract is a way for people to alienate or forego their rights in order to obtain other benefits. So, for instance, let's say somebody wants to pay me $200 to house sit their house. Well, and I agree that for at least an hour a day, I'm going to be actually in that house. Well, I've foregone my right as a result to stay away from that house. I've foregone some of my freedom of movement because I've agreed to be bound to do that thing, to be at that house for an hour a day. In return, the person who's making the contract with me has foregone the right to their $200. Provided that I meet my side of the bargain, I have the right to their $200 and they must pay it to me. So you can see what consent theory is saying is that contracts are really about the trading of rights. I don't know about you, but I really do find that a little bit less helpful than promise theory, and I'm not really convinced that consent theory and promise theory are any different, because Promise theory is really about saying, well, here is my promise, which involves foregoing rights, and you can enforce that promise. I'm just not convinced that they do anything terribly different. But for those of you, there will be some of you out there for whom consent theory is a lot more appealing than promise theory, just as long as you realise that they really do end up in around about the same place. The next thing I want to talk about is contracts and relationships. Now, this isn't really a separate theory, but the right place to talk about it is here because it does affect the way that we see contract law fundamentally and from more of a theoretical perspective than anything else. And the first dot point there on the slide is the important one. Contracts usually happen in the course of broader relationships. So let's say you have a good mate. You've been friends with this person for years. You care about their well-being. They care about your well-being. Having them as part of your life is really important to your life. And they're trying to sell a piece of electrical equipment, say a DVD player or a PlayStation or something like that. And they're a little bit hard up for cash, so you decide to buy it from them. And they ask for a certain amount of money and you think it's a bit on the high side, but you decide, look, what the hell, I'll pay the money anyway. So you buy this item from them. You take it home and within 2 or 3 days it stops working. Now, according to any sensible understanding of contract law, you should be able to go back to them and say, look, you've breached our contract. You've given me a piece of electrical equipment here that doesn't work. I want my money back. Either that or I want to go out and replace this piece of equipment and do it at your expense. They would be, from a contract law point of view, very legitimate things to do. But are you going to? See, in that situation, a lot of people won't enforce their rights. And the reason they won't enforce their rights is that the preservation of the relationship is much more important to them than getting the money that they're entitled to under the contract law. So a view of contracts that takes into account relationships says that the contract may not be the only document which provides an understanding of the business relationship or the business obligations between two parties. It might be that you have to look to the entire relationship and to the entire set of objectives for each party to understand how best to interpret a contract. Equity law. Now, I'm not sure how many of you will have come across the concept of equity law. Those of you who are doing our introductory course at the moment may not have learned about equity law yet. Those of you for whom this isn't your first semester, you probably have come across the idea. But let's talk about it very briefly in terms of contract law. Equity law developed centuries ago when the common law was going through a period of time where it had become incredibly unwieldy. Equity law developed in what's called the Chancery Court or the Chancellor's Court in the United Kingdom. And the Chancellors were all religious people. And so their background was in ecclesiastical law, which is what we call a law of conscience. And so, unlike the common law, they really did look to the vibe of the situation. They really did ask, what does justice require here? Now, eventually, over the centuries, equity law became just as hidebound and just as internecine as the common law, but it started out with all the right ideas. And some of those equitable principles have remained in place through all of these centuries. So sometimes in contract law, equity might step in to prevent unfairness, even if the written law or the written contract does not. For instance, there's the idea of unconscionability. If a contract is so unconscionable that the law simply will not contemplate enforcing it, then the contract might not be enforced regardless of what it actually says. As we go through this course, there'll be quite a few times where I point, particularly when we get to contracts B, where I point to particular legal principles and say, this one comes to us from equity law. At the moment, all I really want you to understand is that there is this body of laws out there which we refer to as equity, and that it's an entirely separate body of law that sometimes touches on contract law, and that its foundation is the idea that justice should be done and unfairness should be prevented. The other source of law that we need to talk about is the Australian consumer law. Now, the Australian consumer law has only been with us since 2010. Before that, each of the states and territories had their own consumer law. Okay, in Queensland, we had the Sale of Goods Act, which actually still exists, but it does much less work now than it did once upon a time. The Commonwealth had the Trade Practices Act. Some states and territories had 5 or 6 different acts which regulated some aspects of how contract law was done. Now, you can imagine that this made life very difficult for many companies, because Australian companies were trying to do business usually in more than one state of Australia, and they found that if they were in South Australia, they had one set of rules to work with, in Queensland another, in Tasmania another, and so on and so on and so on. So relatively recently, 2010 in fact, the states and territories and the Commonwealth all got together and said, right, how do we harmonise our law? How do we harmonise the laws that we have for the protection of consumers, so that business operators who are doing business in Australia can follow the same set of laws regardless of whereabouts in Australia they're actually trading? And what they came up with was the Australian consumer law. Now, the Australian consumer law is it's a very long, very detailed piece of legislation, and for the purpose of this subject, we're not going to look at the whole thing. We do spend a whole week looking at the Australian consumer law in topic 11. At the moment, what I'd like you to know is that its main focus, as far as most of the contracts we'll ever be dealing with, is the protection of consumers. And consumers are folks just like you and me who are not making contracts in the course of business. We're just making contracts in the course of our normal private existence. What the Australian consumer law does is it protects consumers against misleading and deceptive conduct, which is things like false advertising. It protects them against unfair contract terms, particularly in standard form contracts. So businesses can't get away with putting a bunch of boilerplate in front of a consumer and saying, all right, sign here, this is our standard contract. And third, the consumer law protects against unconscionable conduct, which is conduct essentially that is so morally wrong that the court simply will not enforce it. So at the moment, just understand that the Australian consumer law is out there, and I promise that you'll understand all about it by the end of week 11. So there we go. That brings us pretty much to the end of topic 1. During the topic, we've looked at the nature and purpose of contract law and why studying is a necessary evil. We've looked at our 3 key theories of contract law: classical theory, promise theory, and consent theory. Now look, I promise you that when you are going through the material for this semester, if you start finding that there's stuff that you really are struggling to understand, not from the detail perspective, but from the perspective of why on earth do we have this part of contract law, one of the things that you can do which will help you is go back to the idea of classical theory, promise theory, and consent theory, and say, okay, how does this item of contract law help us if we're looking at contract law in terms of making a private law between 2 people, or if we're looking at contract law as a means to enforce promises, or if we're looking at contract law as a means to allow people to grant concessions in relation to their rights. We've talked about equity law as an outside source of law with an impact on contract law. And we've talked about the Australian consumer law, why we have it, where it's come from, and the fact that its impact on contract law, as we'll be studying it, is mainly on contract law as it affects consumers. All right, hopefully some of that made sense. I've got a heap of readings there for you to do this week. My suggestion with the readings is that you start with the notes. because if you read my notes, you'll get your head well and truly around the topic area, and that you then go to at least a couple of the cases. I recognise the reality that very few, if any of you, are going to sit down and read the entire cases from beginning to end, and there's probably, frankly, better ways for you to use your time. But what I think you really should do is pick at least a couple of the cases which seem interesting to you after you've read my notes, go through them, and see if you can read the case in context from the notes. Follow the reasoning of the court, so that you're not just looking at what my assessment of those cases is. You have the opportunity to actually assess the case for yourself. At first, this can seem a bit time-consuming, but it really is important because it provides you with your first opportunity to do some genuine legal reasoning rather than requiring me to take you by the hand. And the more opportunities that you have to develop strength in this legal reasoning process right now in first year, the better off you're going to be when you come to those more advanced subjects. All right, well, I hope this has been an interesting 40 minutes for you, and I'll look forward to our week 1 tutorial and look forward to next week's presentation.